Well, I think environmental protection in this world and environmental rights have become human rights, fundamental rights, because it's a precondition to enjoy all different rights. And the role of justice, or one of the main roles of justice, is to protect fundamental rights. So I think there is a direct connection, and it has been pronounced by international courts. There is a major decision by the Inter-American Court of Justice endorsing what I just said. Um, it stems from international treaties, and many domestic constitutions, national constitutions, do provide for environmental protection, as is the case of the Brazilian Constitution. There is a provision, Article 225, that states that a balanced environment is a fundamental right, and to assure it is a duty of the government and of the community. And it has a very detailed description of what the government needs to do in order to enforce that right. So in sum, there is a direct and necessary connection between justice and environmental protection. Well, the agenda of the Brazilian Supreme Court, as the agenda of any court of justice or any constitutional court, it's to enforce the Constitution. And in the case of Brazil, the Constitution do have provisions relating to environmental protection. That's one thing that I think I would like to explain. The Brazilian Supreme Court plays a role in Brazil that is a bit different than the role played by Supreme Courts or constitutional courts in other countries. And that's due to a few facts. The first one is that the Brazilian Constitution is very comprehensive. It's very broad. It deals with subjects that in other parts of the world are left to politics. So the Brazilian Constitution, as any other democratic constitution, it deals with separation of powers, it has a Bill of Rights, and it organizes the state. Brazil is a federal state. But besides that, the Brazilian Constitution also addresses the social security system, the tax system, the budget system, the education system, the healthcare system, the protection of the indigenous communities, the political parties, the protection the protection of the family, of children and adolescents, of the elderly, and the environment. So the Brazilian Constitution deals, as I said, with issues that in other parts of the world are left to politics and to ordinary legislation. When you bring a matter to the Constitution, in a certain extent, you remove it from politics and you bring it into law, because those provisions can be grounds for lawsuits that are filed claiming for rights or situations that are provided for in the Constitution. So in Brazil, the border between law and politics is a bit more difficult to draw than in other parts. Despite that, speaking to a U.S. audience, to get to the Supreme Court here in the United States, usually you need what is called a case or controversy requirement. In Brazil, we do have case in controversies and a cousin of the writ of certiorari, which is a way that a case will climb to the Supreme Court. However, We also have in Brazil direct actions that you can file directly before the Supreme Court, challenging the constitutionality of a statute or the lack or insufficiency of a public policy provided for in the Constitution. And these direct actions can be filed by a whole lot of public and private actors. And this means that in Brazil, almost anything of some relevance can reach the court, because all political parties can file direct actions, all governors can file direct actions, all class entities of national reach can file direct actions. So the court in Brazil, the Supreme Court, decides the most divisive issues of the Brazilian society, for good and for bad.